Hello, hello, hello. We
This
got
is
a
in the
mystery.
District Court of Butler County, Kansas, case entitled In the Matter of the Marriage of Amanda L. Watson and William A. Watson. It's case number 2023 DM 300.
Oh, Lord. This is from Law Nerds Unite, or as I like to call him, Zach. I believe there may be some love boat involved.
0085. William Watson appears, apparently representing himself. Amanda Watson appears in the office of his attorney. And I don't know that Margaret Lyons.
Yes, Judge.
Okay. This matter comes before the court at this time for hearing on Mr. Watson's motion to enforce parenting time in this case. Mr. Watson, what is this all about?
Sir, Your Honor, there has been a complete breakdown of cooperation between Ms. Watson and I. I simply want to return to the 28 March court-ordered scheduled parenting time that began on 31 March of 2024. Based on the start date of exchanges from 31 March, when I received them for the first time, we are currently exactly opposite of that schedule, meaning she has the kids when I should have them, and I have them when she should. We're exactly flip-flop, which you might think, what's the big deal? As long as everyone is agreeing and it's 50-50, everything should be fine. Unfortunately, this is not happening. We do not agree, and it's not 50-50. The primary conflict started when we worked out an exchange of parenting time that was never followed through on. While attempting to rectify the situation, there has been nothing but stonewalling and intimidation by Ms. Watson and her counsel, as can be highlighted by the exhibits of the communication between us. Text after email, they have done nothing but ignore my requests and protests while offering no reconciliation to this matter. Ms. Watson has solely dictated what time she will have them with impunity, as I've decided not to raise the discourse to the level where the kids would potentially see the conflict, i.e. I didn't pick them up from school when she told them to take the bus to where she's living, as opposed to, or call the sheriff to come over and involve them when I needed to pick them up. So essentially the deal was, I'll attempt to explain to the best of my ability. Because we're still under the temporary order, sir, there's been no concessions made for holidays. So this has gone on entirely too long, and it's week on, week off. Based off of the week to week, I was going to naturally have Christmas. My intent was to plant seeds of.
Oh, sweet Jesus. He seems like a nice, sincere guy so far. I don't know. We'll see. The jury's out on that. But he seems reasonable, and he seems intelligent, but he needs an attorney in the worst way.
Intent and goodwill, and asked her to meet me in November. I understood how important Christmas was to her, and I showed up to the meeting with a plan to work out the holidays, with her having Christmas and an already authorization to go to Colorado. I showed up with a calendar, pages 2 and 3 in my exhibit. I think she also put it in there. On the sheet were the dates that were the parenting time as scheduled per our agreement, and dates I wanted to change in order to allow her to go to Colorado to see her family, the exchange dates essentially. I described the markings to her, which she acknowledged she understood in the 23 January text message to me on exhibit pages 30 to 31. However, she goes on to say, we agreed that after I gave her time.
No, this is an example of why it's awesome. I mean, who wouldn't want in on this situation?
In December, that we would go every other week, and it made sense for the boys' routine. This is where the contention lies. She did not exchange on January 20th like she was supposed to, and the calendar shows, thinking we weren't going to do it that day, and she instead held on to them. The calendar highlights every single thing I proposed, and every single thing she wanted to change is in her handwriting on the sheet. As you can see, there are 0 marks or remarks or changes for that week of the 20th. She simply wrote in mom on the weekend when it was going to go back, but there was no changes made. And she expects everyone to believe that there was some kind of agreement outside the document that I said that I agreed to outside of the document that wasn't on the document. The document existed purely for the purposes of figuring out who.
Here's like, seriously, I hate to like be teaching here. I know everyone hates it, but this is a great example of an intelligent guy. I understand where he's going, but he does not know how to put his thoughts together, number one, and say it clearly. Number two, he's too close to it emotionally. He just needs an attorney who's this isn't his marriage or her marriage, and they step in and say, all right, we had an agreement, they're not abiding by it. Next. Let's fix it. That should be this whole speech.
Would have the children and when the same document with those very same markings in December were executed exactly according to their markings when it meant an inordinate amount of time of parenting directed for her. But when it came to the time to even it out in January, suddenly there was baseless claims of somehow I agreed to give her this time, and then I was perfectly cool with just going week to week after that. That aside, fine. Maybe there's a miscommunication. I understand that. And, but I don't think it was just a miscommunication. I think it was more nefarious than that. But clearly, I cannot prove her intent. All I know is
I don't
time
know.
was stolen. I
haven't seen it.
bamboozled, and I can accept that. But with the weeks as they are now, she could easily say, this is my time, and not give them back again because of the way they are. I got her week and she's got my week, and we keep on going 50-50 because
she isn't abiding by the agreement. I don't trust her going forward. We need to put it in writing and stick to it. There, I've said everything he said so far, just better.
Decided I'm not going to argue anymore. And so here we are, 50-50, and she might go, you know what? I'm keeping them. You agreed in some kind of verbal manner that that I would keep them this week. I don't know what you're talking about. And then use her lawyer. I no longer have a lawyer anymore. Can't afford it. So, and then I get ran through yet again. And I just want to prevent that. So what I'm asking is
you can't afford not to have a lawyer, my friend. My God.
Just so we go to our weeks. I even said in the very early emails on January 17th and 22nd, like, I will take more time loss just to be on schedule so that I can't be taken advantage of later. And I've gotten nothing. I've gotten nowhere.
By the way, I haven't heard from her, so I'm not assuming he's right. But let's say he's right about some of this stuff and he's wrong about some of this stuff. The other thing is an attorney will look at it objectively and say, let this crap go. These are good arguments. These are bad arguments. And then just narrow it down to what needs to be done and win on it.
Just the runaround. I've texted or emailed with her counsel. I've texted her and emailed her, and and here we are. To settle something as simple as this, we have to come here. And anyway, sir, that's why we're here.
All right, Mr. Watson. Ms. Lyons, your client's response?
Thank you, Judge. Preliminarily, I would ask that the court strike the respondent's exhibits from the court file itself. They contain settlement negotiations between myself and Mr. Watson. KSA 6452 does not permit those be included. He's pro se. I understand it was probably an oversight, but it is now currently in the actual record of the case file. So
yeah, exactly. Like this is like dumb stuff that he doesn't know any better. It's not malicious intent, but it's dumb. Like you can't attach that as an exhibit. But somebody who practices in that area knows that.
Ask that those be stricken. As far as his requests,
She could actually ask for sanctions for that.
I do find the presentation
much,
to be a
but-
bit disingenuous. At no time has my client asked to switch the weeks back. In fact, we've been pretty adamant that they've been doing this exact schedule for months, since December 1st, and that to switch the kids again is unnecessary and adds unnecessary conflict and disruption to their schedule. The parties reached two separate agreements to change the prior court order to work better for their families. First, in October, they reached an agreement to switch it from Sunday to a Friday exchange because Sunday at 7 doesn't work for the kids' sports schedules and school schedules, etc. That agreement is in my exhibit notebook at exhibit 3, page 9, 9 to 12. It starts with Mr. Watson's proposal to switch it, followed by my client agreeing on the next page. Does the court have a copy of my exhibits? I probably should have asked that at the top.
I think so. Are each page individually identified?
It should be. My version is. I guess I didn't check what we mailed to the court. Mine has Bates numbers on it, Judge. Does yours not? There should be colored calendars in there.
I see those.
Okay, it's right after those.
Okay.
Then the parties met, and again, that period of time, Mr. Watson was represented by counsel. This was an agreement that the parties reached, implemented, well represented, et cetera. It wasn't a case of a pro se being taken advantage of. Then they met again in November to figure out what they were going to do about the holiday schedule. My client had asked through counsel and directly to Mr. Watson for some Thanksgiving holiday time. That request was denied by Mr. Watson. He said it was, quote, foolish of her to even ask. They did meet and figure out a schedule for the Christmas holidays, Christmas break, etc. That was entered into their shared calendar on December 1st, Judge, and that's what they've been doing ever since. The exhibit 2 in my notebook, it's also in Mr. Watson's notebook, is that written agreement. But I would argue their actual, what they've been doing matches it exactly. They've stayed on that same schedule. Mr. Watson then filed this motion demanding that they switch weeks so that he would get either 2 weeks back to back or my client would get 2 weeks back to back for reasons I cannot understand. And it's been my position, my client's position, that there's just no reason for it. So, but the problem has been that he has stated in writing repeatedly he will be showing up at my client's house uninvited to pick up the kids. Then he stated, oh, just kidding, I got it backwards. This week's actually your week, not my week, so I'll come get them on another day. All we are asking for is that the court leave in place the current schedule that they have been following, this week on, week off schedule. It's been months now, Judge. The boys are used to this particular rotation. I would also add that the respondent's claim that days were, quote, stolen from him is not borne out by the calendar, one, but that issue has been specifically submitted by Mr. Watson to domestic conciliation. The parties have now been in domestic conciliation. Unfortunately, it's taken a little bit longer than we were hoping for. Mr. Watson didn't get his documents and payment in on time, but he submitted this specific issue to domestic conciliation. The parties have already paid their domestic conciliator to address this issue. We're anticipating a recommendation any day now. The only reason—
Who's the domestic conciliator here?
I'm sorry?
Who is the domestic conciliator here?
Paula Langworthy.
Okay.
So I'm sure the court knows she's very efficient. She will get this resolved and has been asked by Mr. Watson for a ruling on this issue. So these things as to whether a day here or there is unbalanced will get addressed by Ms. Langworthy. I would argue, though, that the calendar reflects not what Mr. Watson is asserting to the court. But the parties and their children need some consistency unless and until we reach some change through domestic conciliation. The parenting time, what it's going to be, all of that is up for consideration in domestic conciliation. So to change it now doesn't make any sense, Judge. They've been on this schedule now by agreement since December 1st. It's been months. We should leave it in place. both for judicial economy and for consistency for the children. Now, if domestic conciliation comes out with a different schedule and we need to petition the court to change the schedule and all of those things, we can deal with that at that time. But to change it just because Mr. Watson is afraid my client is going to change it, something she has been adamant both directly to him and through me, she's not going to do. And we were prepared to do an agreed order confirming this if that was his concern. We didn't get anywhere, Judge. So we're just asking that the court simply issue an order that will make Mr. Watson feel comfortable, that no one's going to take his time from him, and that confirms the agreements the parties have put in place for the best interest of their children. Because again, KSA 233202 specifically states that agreements of the parties are presumed to be in the best interest. These are agreements these parties reach voluntarily outside of counsel based on their children's schedule. They have 4 very active young men that they are raising with sports, etc. So that's part of why they've changed the schedule 2 different times since then. You have to be flexible with these things. But if it will make him more comfortable and will stop the threats that he's going to come pick up the children and disrupt their schedule, we would ask that the court issue an order that says, this is the schedule. This is mom's week. This is dad's week, and be done with this. Secondarily, though.
Okay, let me back up a minute there. If we restore a new week-to-week schedule, the exchange time would be when?
It's Sundays at 5 by agreement right now, Judge.
Okay, and you're not proposing a change to that?
No, sir.
Okay, please continue.
Secondarily, while we're here, though, because of the disagreements the parties are under, unfortunately, right now, my client requested for her week this year, it's spring break, to take the boys to visit her parents in Colorado. Mr. Watson is currently denying that trip, he says, because they're not communicating well enough for him to consent to the boys leaving the States. We would ask that since his parenting time is not in any way impacted by this trip, that my client be allowed to go to Colorado to visit her parents for spring break with the boys. The dates specifically would be March 17th through 23rd.
Okay. Mr. Watson, what about this Colorado?
Yeah, attorney did a nice job, if you ask me. Even even calibrated appropriately, saying we're frustrated that we haven't been able to just work it out and that we're here, but made it seem like she's willing to work with him.
Trip request. You got a problem?
So that's a blatant lie.
Okay, so you don't have a problem with it?
I have 0 problems with it. What I said was, and that's in there if she can read actually my words. My words were, we have not settled this issue yet, so we don't know where they're going to be. So how can I say, yes, go to Colorado if we come out of this and the court says, I will get time back. And oh, by the way, spring break is a good time to perhaps have some overlap where it won't be hard for the children, just like it was during Christmas when I gave her 17 days in a row. So perhaps coming out of this, there wouldn't be a problem. And so I told her we would just wait on that. I have 0 problems with her going to Colorado.
All right. So this is currently mom's week then.
Say again, sir?
Under the current schedule that you're actually following. It's her week.
I missed the first part.
This is her week, right? Right now that we're in?
According to the 31 March start, no. But as she has dictated to say, hey, you have them then, and I have them then, and I stopped asking, but said in protest, yes, right now they are with her.
Okay, which means that you would have the children next week. The week of March 17 would be hers.
Yeah.
Starting at Sunday,
yes, Your Honor.
The day before. All right. And your real issue with an agreed order which locks in this new week-to-week schedule to guarantee what your weeks are, you have an issue with that?
No, Your Honor. I do not have an issue with locking in whose week is what. But I would like the court to say so that it is in writing, we have it, so that there can be no, because our communication is broken down. I don't trust in the least bit anything that she's.
I get it. This is so workable. This is actually a good thing to come to court with because they need a third party. He has reason to not trust her. and he's also a little too cranky and doesn't know how to handle it well. Both of those things are true. So the judges, I haven't seen this yet, but the judge is going to craft an order and say, okay, there it is. And that will probably fix it here. He just wants to know when he frickin' has the kids.
Says, she never guaranteed me that she wouldn't take it again. That has not been, she cannot find a single thing where she said that. That has not happened. I have been afraid of it since, and that's why I wanted to go. That guarantee has not happened. And even if she had said it, she just did it. What makes me feel like she won't do it again? Oh, we miscommunicated, and then keep them.
All right. The court's first observation, the court finds it disturbing, even tragic, that you two parents can agree on deviations from your week-to-week schedule. Number two, when this court entered orders back in March of 2024, this court never envisioned that you'd get to Thanksgiving and Christmas and not have a final parenting plan in place. I don't know what happened with your lawyers and you during that period. It doesn't take that long to set up and complete domestic conciliation if it's pursued diligently. So I don't know when all of that got started, but there needs to be a final parenting plan put in place here so that everyone knows exactly
I think what he's trying to say is,
no, y'all stink.
rights and responsibilities are. This March 2024 order was only meant to be temporary, a stopgap measure to govern things until final orders were entered. Be that as it may, we are where we are. We're now in March of 2025. We still don't have final orders in the case. And I'm trying to look and determine, has there even been a divorce granted here?
No, Your Honor. We are
And
still
why is that? Why isn't this case pointed toward final resolution?
We are certainly
What
hoping
the-
to move in that direction, Judge. I'm second counsel in. We were able to get domestic conciliation started once I got in, and then his attorney dropped out. But we're hoping
What
that we'll
about
have a final
property that-
custody.
And matters such as that, is personal property and all property already been split up between the parties, and that just needs to be memorialized?
No. We were working on that with his counsel, but then she withdrew.
All right.
And the domestic conciliation is taking extremely long, just because we apparently can't agree there.
That's not quite
It really
accurate.
is dragging out.
He has missed all of the filing deadlines in domestic conciliation as far as I'm aware.
I have not missed a
Good news
single
about the
deadline.
court's initial orders is that it really it tried to treat both parents as equals by
Yes.
giving you equal parenting time and equal involvement in the lives of your children. A week-to-week schedule, which you two deviated from. And while it's a shame that you can't agree on modifications or agreements and you simply follow them, the court just needs to get involved again and reset the schedule. Starting with Sunday, March the 2nd, the court enters an order for a new schedule with the mother having
Seriously.
the first week of the schedule, again, starting 5 o'clock p.m. on Sunday, March 2, with there be a rotating week-to-week schedule where the children spend 1 week with the mother, then 1 week with the father. So in other words, his first week under this order would start on Sunday, March the 9th, with the mother again, March 16, and so on and so forth. I would like to see that you two could have some flexibility for special occasions. But if not, then the parent who has the right to custody gets the holiday until you can work out a final parenting plan, which is something that domestic conciliators are quite skilled at if you have two people that are participating in good faith. Those are just minor details that can be worked out. I do have a general rule, though, that mother gets to spend Mother's Day with the children. The father gets to spend Father's Day with the children, regardless of the schedule otherwise. So if the exchange has to take place in the morning or the night before to make that happen, then that's what needs to happen. Other than that, I'm not inclined to try to set forth a full holiday or special day schedule. I would hope a parent with custody would always allow access to the kids on birthdays and that kinds of things. But that's something to be worked out, I think, comprehensively as part of your domestic conciliation that you're involved in. And I hope that that goes quickly and smoothly. to get a final parenting plan in place. Again, it's still the intention of the court to treat the parents as equals here. Furthermore, we've got a pending divorce case with no resolution of any issue in a final basis. That needs to happen. Mr. Watson, you're not going to get substitute counsel?
Your Honor, I am still paying 100% like what they call it, child support, because the last time we saw each other, it was only thing that was because of her counsel was withdrawing. It wasn't even seen to change the amount of money I was paying her, even though now I'm 50-50. I'm buried under
Well,
child
you should
support.
be paying child support, except under a shared custody plan. Mr. Watson?
Yes, Your Honor, but that's what is currently happening because that's what's on the books. So that's what I'm paying, because there has been nothing otherwise. And at first,
And this is, I don't know if I trust everything he's saying, but it does bring up common issues. I mean, so he's paying full child support, although he has the kids half the time. He's probably paying her attorney, although I don't know. And he can't afford one for himself. It's brutal.
we knew it a while ago, but we thought, it'd be done soon enough and it would all buff out. But after a year, I'm buried. And so she mentioned I did miss one deadline, the very first one with the domestic conciliator, because I didn't have money. And then because Ms. Watson wants to take the children to Colorado, and that pursuit, it's taking forever. We had to give more money to the domestic conciliator. I'm buried.
Okay, well, on that issue, the court will allow the trip to Colorado. It's during the mother's week. It does not interfere with the father's parenting time
Oh,
schedule.
I'm sorry, sir. That's not
Court
what I
will
was talking about.
allow the trip. That can be journalized as part of today's proceedings.
That's
But I hope
perfect.
you have a good time, frankly.
No, sir, Your Honor, I was talking about permanently, and that's why the domestic conciliation is taking so
Okay.
long.
I just want
My man, you've got to get it done. My God, just be happy you are not waking up to that every day. Life is good. It'll get better.
to make sure I got my ruling into the record of these.
Trust
No, that's perfectly fine. I have allowed her to go. I came to the meeting in November with
Much
it on the table, like, please go and see your family.
Just putting aside child-related issues for a moment, Ms. Lyons, what are the issues in the divorce action that are still disputed? What do you perceive to be an issue here?
The issues are as to financial disclosures that we have not received from Mr. Watson.
Like what?
We need retirement statements, we need current pay stubs, because what we received reflected higher income than what he's shown on his domestic relations affidavit. There's been a lot of missed payments as to some of the current orders. I will say those were set in place prior to my entry, but we were working through it with his prior counsel. That got put on the back burner when he switched counsel, well, went pro se. As he has stated repeatedly in this hearing, communication has been difficult because he doesn't trust what my client and I are saying. So that's sort of where we're at with that piece of things. We were hopeful to settle some of the smaller issues as to like personal property, for example. And we had made quite a bit of headway with that with his prior counsel, and then that has stalled out. And there's been some financial strain on both sides that have slowed that piece down. So our hope was to just resolve it all once the domestic conciliation recommendation comes out, and then coming 2 to 3 weeks is what we're hoping.
Is the domestic conciliator being asked to be involved in financial matters or just child?
No, we're just hoping to do a global resolution of everything in a couple of weeks.
I would like to see that happen, obviously. This case needs to get moving through the system.
Yeah.
Or
Yes,
be
sir. I have been.
a lack of prosecution. This is how cases get on a 2-year overdue list that this court has to deal with from time to time. This case isn't going to last 2 years, I can assure you that.
No, Judge, certainly not.
We're past one already.
Yes, we will absolutely work on that. Does the court want me to draft an order, or do you want the minute
I do.
sheet to serve? Okay, I will do that.
Watson, I don't want any unreasonable objection to the orders that stem from today. They're probably going to be emailed to you for your review. And then I'll expect your approval. If it's in accord with what the judge has said here on the record, then you should give your approval so we can get this order on file.
Exciting and new.
I think it's
Yes,
in
Your
both
Honor.
of your best interest to have this order clarifying your parenting rights in place.
Yes, Your Honor. I
So-
absolutely want that.
She normally would be dealing with your attorney, but she's going to have to deal directly with you on this. So I want you to look this over before it's submitted to the court. So I have no doubt Ms. Lyons will draft consistently with what the court has ruled today. We're not going to leave here without another court date. So the question is, when do we set this date and what will this court expect to be done between now and then? First, I want to know what's the realistic time frame for receipt of the domestic conciliation report. Do you have a date in mind here, Ms. Lyons?
I did call that office or speak with the office this morning. Her father died.
Oh.
That is slowing things down. So I would imagine we'll have it. I hate to put words in her mouth because she didn't have an estimate. She said she's almost done with, she's moved to the investigation phase, calling witnesses. She started all of that yesterday. But I don't know. I would think this month.
All right.
I would think.
Set this case for review in April.
Judge, I am in truly unfortunate timing. I am going to be out on maternity leave.
Oh, well, congratulations on that.
We've got a whole thing happening here. Things
Okay.
are out of hand. I do have someone in my office though that is going to try and cover the case just to keep it moving because we don't want this stalling out while I'm out.
When do you expect to start your leave?
March 26th. I just scheduled it actually.
Okay, well, that may be a little bit quick.
Yeah.
Reschedule this case. But if there's someone in your firm that can take your place at a review hearing, the court's going to be inclined to set one.
Yeah, I'm gonna try and find somebody. The problem is just getting up to speed on a new case is challenging and expensive. My plan was to continue trying to work with Mr. Watson throughout leave. I won't be in a position to make court appearances, but hopefully I can do some emails and get settlement offers sent out. Again, get that process restarted.
All right. I'm looking at Monday, April 21 at 4 o'clock.
Okay.
This will be another Zoom status conference.
Okay.
April 21 at 4. We'll review the case. We'll determine status of the domestic conciliation report. But in the court's view, that doesn't necessarily stop negotiations or discussions regarding the financial issues that need to be resolved as part of this divorce case. Is there real estate involved in this case?
Yes,
Who's got the house?
my client.
Okay, well, obviously there needs to be some determination of that.
Mhm.
Yeah.
Personal property, there's some obviously in each party's possession at this point. What more has to change hands, obviously, is something that has to be discussed. Counsel, in all candor, it would appear that if the original child support order that was entered in this case was based on one party having primary custody, and then this court ordered in March of last year shared custody, there may be some retroactive child support relief, which is called for here, perhaps as something to be talked about during negotiations. But he should not be ordered to pay a full child support amount in a shared residential custody case. And there should have been a new worksheet prepared by the attorneys involved in the case at that time. I'm not sure how that got missed.
I pulled the transcript. That issue was not even requested or argued at the hearing, so I think that's how that got missed. But certainly, again, it's part of the global resolution, at least from our perspective. Just
Again, a matter to be discussed
out.
and
Yes.
eventually resolved.
yes.
All right. And Mr. Watson, if you're not able to retain an attorney, then you need to be able to talk to Ms. Lyons or a representative of her law firm regarding this case.
Yes,
and
Your Honor.
some good faith
fully-
negotiations.
Yes, Your Honor. There's
Uh,
not a lot. Really, we don't have much.
Strangely, some of the cases where there's very little assets or debt are the ones that are the most hotly litigated. I'm not sure why, but sometimes that's just the way it works. But it doesn't have to happen here. For Watson, with just some give and take on both sides, you might be able to reach a resolution of all financial issues with a little bit of positive discussion. So I'll
Absolutely.
expect
I'm
good faith negotiations. That's what the court demands at this point. And we'll review this case, and I hope that there's some progress to be reported April 21 at 4:00.
Judge, was my request to strike the exhibits from the court record granted?
I will rule on that. The court's going to order those sealed. They will remain part of the case, and they will be under seal. They will not be a public document. Mr. Watson, I realize you're representing yourself. Had that been brought to my attention, I wouldn't have allowed you to file it. Quite frankly, filing exhibits as pleadings in the case is inappropriate in the view of the court. It's not that they're not relevant, but they're to be presented as part of a hearing record, not filed in the case. The other side has no opportunity to enter an objection to their admission or consideration, and placing those in a public file under most circumstances is just simply inappropriate. Lawyers can't do it in the view of the court, and pro se litigants can't do it. So from now
Yes, sir.
on, hold on to your exhibits. You don't necessarily need to file them in the case. But I'm going to order what has been filed and accepted by the clerk's office sealed from public view.
And sir, Your Honor, just so I'm sure, you said my entire packet was not
Your
to be
entire
filed?
packet. It was essentially accepted as if it was some sort of legitimate filing, and it was an
Huh.
exhibit packet, and we don't file exhibit packets generally as just part of the public file in the case.
So I went to the wrong part of the courthouse to.
No. I'm just saying your exhibit packet is not
Oh, sweet Jesus. No, you went to the right part of the courthouse. You filed the wrong things.
an appropriate filing in the public file. And I'm going to
I get it. If you don't do this, you wouldn't know. Which is why you get someone to help you.
order it sealed. It'll be accessible to the court, but it's not to be part of the public file.
Yes, Your Honor.
Sometimes I've seen over the years absolutely spurious materials being filed by a pro se litigant thinking that the court has to accept any paper that they bring them. This court does not share that view. I've seen even pornographic materials where people have attempted to file them in a public file in the case.
Of course.
So there are some good reasons why we don't just blindly accept.
I can see that. Pro se's filing with the court, their revenge porn. Having no idea that you can't do it.
Every single document that's someone thinks is a relevant exhibit and accept that into the public file. So I'm sure that you were proceeding in good faith, Mr. Watson, but I'm going to order this packet sealed. Okay.
Yes, Your Honor. I thought in the email that I got from Miss Mandy, I was supposed to bring.
Then you should have sent it to her. If she directed that you submit something to her, then that's where it should have went. It should have went directly to my office.
It'd
That happens
definitely
from
make us
time to
get worse,
time in
wouldn't
these Zoom cases. An exhibit notebook is delivered or an exhibit packet is delivered in person or by email. That doesn't mean they're going to be accepted by the court, but at least we receive those
Okay.
in that fashion. And they don't go to a public file like they do.
So I needed to go and
Apparently
give it
file
to.
this with the clerk's office.
I needed that.
So you needed to go and hire another attorney to take over for the last one, because this isn't the end of stuff that you don't know. Okay? For instance, like maybe file a motion to switch your child support payments, and maybe even ask for a credit for the back child support payments. You clearly don't know how to do that, or you would have done it by now.
Ask for Mrs. Mandy. Okay, now I see where I screwed up.
Okay, good. Then the court has made its ruling in that regard. Go ahead
Yes,
and
Your
include
Honor.
that in the order.
And my sincerest apologies.
It's all right, Mr. Watson. We'll go forward from here. All right.
That's just straight ignorance. That's not sleazy. That's not trying to gain an unfair advantage. That's him honestly doing what he thinks is right, and it's completely wrong.
Again, you've got a new schedule established by court order, and I hope I can get this in my queue for signature and filing with the court as soon as possible, Ms. Lyons.
Absolutely, Judge.
Okay. All right. Ms. Lyons, anything else that the court needs to rule upon at this time?
No, Your Honor.
All right. Anything else at this time, Mr. Watson?
No, Your Honor.
Very well. Thank you all for your involvement here today. If there's nothing further, the Watson matter will currently be in recess. This meeting may be ended for all this time.
Give me a call or email me. Okay.
Okay, thank you.
All right, I got this sent to me. Who sent this to me? Angela McMaster sent this to me. This guy rolls into DeSanto.
Okay, thank you. Have a good day.
Thank you.
Have a good day.
It
Okay.
might be time to retire.
then-
Clerk, I have Daniel Tinth.
Oh, hold on. Okay, excuse me. Let's go off the record. Counsel, when I'm trying to call a case on the record, I can't have you just interjecting and interrupting the record. What is it you indicated, counsel?
I'm here on Daniel Tinth, Judge, for the third time. And all we're going to do is ask for an exam date.
Have you already spoken to the prosecutor today?
I don't think I need to talk to a prosecutor to get an exam date unless you want me.
Hey, jackass, the question was, did you talk to the prosecutor? Not, do you think you need to talk to the prosecutor? Presented to you by the judge. Just answer it.
To agree to a date with him. That's fine.
Yes, because the prosecutor has the file, and we don't know when the file is ready until after there's been communication between the attorneys, and then he sends that in with what's happening. So we're going to put you in a breakout room with Mr. Matherly.
Thank you.
And the next time, counsel, if you can just wait until we're asking for something, we're going to check people in so that it's not interrupting the record, please.
Okay, Judge. I just wish, that your court answered their phones.
Counsel, as I stated before, we are severely understaffed. We have people that are out sick. So
Judge, there's no reason why for 4 days, me calling from 8:30 to 4:30, that nobody answers your phone in any department that I dial. So I have an issue with that. Yes.
Mr. Margolis, again, I take it.
You should hold him in contempt right there. It's totally inappropriate. First of all, I mean, the guy looks, looks like he's no spring chicken. I'm shocked that he has that expectation of a court. This kind of stuff happens all the time. Courts are notoriously inefficient. They're government units. It's frustrating. I'm not saying it's okay, but you don't expect grand customer service from the court clerk literally anywhere in the country. And to raise that in that tone on a public call, worse than that, on Law Talk with Mike, is just poor form. You just look like a big blubbering baby.
Exception to your continuing interruption when I'm speaking. As I've stated, it is most effective to send in an email to communicate with the court, because we have one of my staff members that's here in the courtroom. We have others that are out ill. So that is what we're dealing with right now, counsel. So as I stated before, the most effective way to communicate, to find out a question, to ask anything, is to send in an email.
I know, Judge. The last email I sent took me 2 days to get the answer, and after the court told me that they were calling me back. So respect goes 2 ways, Judge, with your court. So yes, I
like the psycho teeth shot too. You look like a maniac, counsel. You look like an absolute loon. I want you to review this and think about your actions. I truly do, on behalf of the profession. I don't think I would survive without a contempt before any judge that I've seen in the last 10 years acting like this.
I try to be respectful, and I will be respectful in the future.
Oh,
Well, I will check into that to see, because typically.
that's great. That's your bare minimum legal, ethical obligation. Thanks for that magnanimous gesture.
It's only within a couple of hours. So I will check that to see what happened in that regard.
Well, should I stay on Zoom or should I call back? Because I have 4 other matters this morning.
We're putting you in a breakout room with Mr. Matherly, counsel.
And then do you have him on Zoom from the prison or not?
Your client
Or
is
do we
here.
not need him?
Would you like to speak to your client?
Well, just put me in the breakout room with the prosecutor, Judge. Thank you.
I'm sorry. Well, I'm sorry, Mr. Willis. You're telling me to just put you in a breakout room with the prosecutor. Is that what you're telling me?
Yes, I've already talked to my client. We're ready to go. It's just a matter of getting a date with the prosecutor.
So he's going to tell me what to do. We're putting you in a breakout with Mr. Matherly.
That's what you said. Man, I'm ready. I'm waiting.
I'm torn between. He's completely out of line, and I don't want to say too much because I don't know, and I don't know him, and I don't know his personal circumstances. But I'm guessing that they aren't great, and I hope people close to him discuss this with him. Is the best I can say.
Mr. Kritz, are you ready on your matter? Mr. Kritz? $15th, after your evaluation. All right, thank you. Anything else, counsel?
Yes, Judge. Thank you and have a great day.
Okay, you as well. Thank you.
Thank you.
All right, have a good day. We are on the record. We are recalling the matter of Daniel Tim. And counsel, your appearance, please.
Elliot Margolis, P28078, on behalf of Daniel Timp, Judge.
Okay, we just need to move him back into the main session here. Counsel, can you jump back in there so that you, on your device, and let him know that he has to join we've requested for him to join the main session.
I can't understand you again, Judge. Your voice blends into, for some reason, you're the only judge that I cannot understand, and it's not your fault, but.
Can you please?
Oh, while we're at it, your nose blends in when you stick it in 2 millimeters from the camera.
Jump back into the breakout room you were in with your client and request him to join the main session.
I did tell him to join back in, but he didn't have any way of doing it, and I told him to tell them to get him back into the courtroom. I've already told him that, Judge. I'll waive his appearance for this purpose. He knows I'm requesting a preliminary examination.
Okay. All right, we can set this for exam. Are you looking for next week, counsel?
Next week. Yeah, does Thursday work for the court?
Yes, it has to be a Thursday. Does that work for us, Ellie?
Yes.
At what time?
How late in the day are you scheduling the day? Because that's when you're off 8 to 1.
Yeah, we do 2:30.
Yeah.
Okay, 2:30,
At what time?
2:30,
2 o'clock in the afternoon?
2:30 p.m.,
2:50?
2:30, 30.
Oh, 2:30. Okay, I'm sorry. I will be there at 2:30 on Thursday the 13th, Judge.
Okay, witness and exhibit list by March 10th. Bond and conditions are continued. Mr.
Thank
Tim? Mr. Tim's back in the session. Mr. Tim?
Okay.
Can
Thank you,
please-
Judge. He's going to need to be writted. He's going to need to be writted from the jail. From prison, I should say.
Counsel, I was still talking. I was saying that Mr. Timpf is back in the main session. Mr. Timpf, please unmute. Mr. Timpf, I need you to hit unmute on your device. Can you hit unmute?
It is unmuted.
Now it's unmuted, yes. Now it's unmuted.
I've never hit the button, so it wasn't on my end.
No, sir, when it moves you back and forth between the breakout rooms, I think Zoom automatically mutes you. So,
Okay, I'm sorry.
The defendant's the most reasonable one in the group. These hearings get so good sometimes. He's like, "Yeah, I got a mute button, but I didn't touch it, so it's not on my end here," which is rational.
no, you're fine. There's nothing to apologize for. All right. So we set this matter for preliminary examination on March 13th at 2:30 p.m. So next Thursday, sir. And counsel, yes, I'm very much aware the court has to send a writ to the prison so that he can be present. Bond and conditions will be continued.
So March
Anything else?
13th?
Thank you, Judge.
Yes.
Thank you.
March 13th. All right, thank you, Your Honor.
You're welcome. Have a good day.
I love the awkward, polite close. I'll give him 2 points for not being nasty to the end. I will. I'll give him 2 points, but I'm not awarding full redemption for it. You can't act like a jerk for 5 minutes and then just go, "All right, thanks a lot, have a good day," and it's all erased. You got more to go than that. Oh, good stuff.
All right, on the record.
All right, I don't know about this. I just ran across this. I'm going to tell you right now, this isn't great. It's awkward as hell. Maybe only I'll enjoy it. But this guy is trying to talk Judge Buchanan into smoking pot. And it just sucks, and it's so awkward. It's so awkward.
Record in State of Michigan versus Jabril McCollum 2403059FY. And you,
I love
go
it.
ahead.
Jeffrey Bill on behalf of the people.
All right, and you're Jabril McCollum. All right, Mr. McCollum, I don't have.
To this day, 90% of my hearings are on Zoom, unless it's like, an evidentiary hearing or something, where we're have witnesses and handing exhibits to people and stuff, which is beautiful. That means I went from not only do I not have to wear pants, but I can do it from anywhere in the world. A fact that I've taken advantage of.
A copy of your card in front of me right now. But you were sentenced to probation for January 27, 2025. As I recall, you got your card real close in time to your sentence and or plea in this case. Is that right?
Yes, ma'am.
So you didn't have a card before you came to court and you decided to get the card just to use on probation.
No, ma'am. I had the card for about 5 years. I have to renew it every 2 years.
Mm-hmm.
So it was due for renewal in November. I had to find a new physician. They have you go through this whole process of finding a new physician
This whole process. The process is you go over to Dr. Feelgood and give him, I don't know, $80, $100, and he says, "Oh yeah, you definitely need pot," and writes the script, and that's that. Who are you kidding?
So since you're on probation for a controlled substance related offense, what I require in order for you to use marijuana on your probation is a letter from your doctor that says that you have a medical condition that marijuana is going to assist you with.
Okay.
Okay?
Okay.
So during this hearing, you think 2 weeks is enough time for you to get that letter?
Yes, I filed for disclosure of the
He just can't like he just can't abstain from marijuana for like a few months until he gets this behind him. That's all this is. There's no medical condition he needs it for. None.
for disclosure. The doctor is supposed to. It might take up to 2 weeks, 2 to 3 weeks. They say for the doctor to sign off on it.
Indeed, I have.
They have me jumping through the loops just to even find the doctor. They don't. They always talk about. It's just.
There aren't a lot of doctors who are that comfortable with this as a treatment. That's why sometimes it's difficult. And so I just need a doctor. He doesn't have to give me the details of your medical situation or anything like that. He just needs to say, Mr. McCollum has a medical condition that marijuana is the treatment for it.
Okay.
Okay?
Yes, ma'am.
This is a doctor for which you have a regular relationship, not a one-off, I want a card. But like, I have a follow-up with this doctor in so many months to see if the medication.
Yeah, I get what the judge wants, but it's just not the world he's living in, you know? He doesn't really have a condition. He doesn't really have a doctor. He just wants to smoke dope. That's it. She kind of knows that, but but then she's got to pretend with this BS. It's fun.
Is helping me.
Okay.
That kind of thing.
Like a main physician.
Yeah.
Yeah. I have problems finding a main physician. I'm on Medicaid and the McLaren.
I'm on Medicaid. Yeah, it's gonna be hard to find a doctor to do that. Yeah, these are cash deals here because there's not a lot of basis for it. So you know that's what we're dealing with.
Didn't know y'all stink. Okay, that's just my opinion.
The McLaren, I got no main physician would even take it in Lansing. I will have to go out of Lansing to find a main physician. Right now,
no, I thought you had. I thought for sure you'd have a regular physician that you see all the time.
they only send me to Sparrow.
Mm-hmm.
So that's where mostly I go for all my medical treatment, just right to Sparrow.
Mm-hmm. That's not great. You're not supposed to use the emergency room like that.
That's what I tried to call the number on the back of the card to find a doctor. That's what they told me. They like me. The only doctor that would take your Medicaid is Sparrow.
But Sparrow has physicians that.
You're not supposed to use the emergency room like that. You're not. But you realize that that's what's happening, right? For a large swath of the population.
Work in their network.
Yeah. That's what.
So it's not the emergency room.
Yeah, no. It's an actual.
So you should be able to get a Sparrow physician who's a primary care doctor.
See, I didn't even think about that. I thought I just go into.
It's like McLaren. There's a hospital, but there's also like a McLaren network of physicians, and I have a doctor from McLaren that's like my doctor. She's not at the hospital. She got a doctor's office, somewhere. I go there. Okay, we're gonna work on getting a doctor.
Yes, ma'am. Yes, ma'am.
If you got a medical concern, you should have a doctor that you can see.
Yes, ma'am.
Okay. Let's set this out 3 weeks. March 28th at 10. Okay. We're gonna get you a court date to come back so you can talk to me about getting a doctor who says that you need to use this medicine.
Yes, ma'am.
Remember, to use it on probation, you have to use it in compliance with the Medical Marijuana Act, which means you have to have a doctor.
Do this today, Your Honor. My health is in jeopardy right now.
What's up?
I have IBS, irritable bowel syndrome, and what's been going on is
Very stressful.
I'm bleeding inside, ma'am.
Need it.
Yes, ma'am.
You gotta see your doctor so that you can make sure that your medical condition's not getting worse and that kind of stuff, right?
Yes, ma'am.
Okay. We'll get you a court notice in just a second here.
Oh, I assure you, his medical condition has gotten worse. He is suffering from acute sobriety at the moment, and he is not happy about it. He is going to hunt down that doctor. His first non-ER doctor visit in his life. To get that script so he doesn't have to go without the ganja for the pendency of this case. That's what we're dealing with, people. It's beautiful. It's beautiful. Thank y'all for coming out. I appreciate it. I'll see y'all soon.